Hi there, it's Michelle Bryant from Property Sisters UK, and I'm joined again this morning with David Kemp from DRK Limited. Good morning, David.
Hi, good morning, Michelle. Thanks for having me back.
You're very welcome. You're very welcome. There's been a lot of interest in your content, and obviously, let's talk about the last week. Huge changes, and yes, a big radical shake-up of the planning system. So tell us about how your week's been impacted with everything that's been announced.
No, God, it's been nuts. I mean, the government basically decided that it wants to kickstart development in this country. It's been talking about giving developers an opportunity for sort of like a fast-track system through to putting new floors on top of their buildings. And so it's created 7 new permitted development rights. 6 of those are to do with existing buildings, and then 1 of them is to do with knocking down existing offices or flats and then putting a new building up, or slightly higher building than the existing building, up in its place. And then there's been a few changes around the use classes order as well, changes to some of the categories, etc., etc. I think it's all very confusing for people. And a lot of my time has been spent trying to perhaps dissect it, simplify it, say what the implications are. And also, for those who are doing prior approvals, so office to resi or retail to resi, you've got to kind of really dig down into the detail of the stuff that's been published to try and understand, well, you know, what are the changes, if there's been any changes there. So, yeah, it's been a lot of work and very interesting times. I mean, I feel as if I'm right on top of it now, as best as I could be, but you've got to put in the hard yards to get there in the first place.
Absolutely. And obviously, I mean, like you say, there's a lot of clarity required out there. And I believe there's still further guidance to come on some of the announcements that have been made, and potentially more changes to come, do you think?
Yes, I mean, there will have to be. For instance, with the use classes order, what they've done is they've changed the use classes order. Because basically the government's looked at town centres and says, well, the traditional divisions of retail, financial and professional, restaurant and pubs, and the way in which town centres work is not the same. It's kind of changed. And also because I think also during COVID, I think socially, as communities ourselves, there are certain things that we've realised we really miss much more, or we rely upon much more. So, for instance, essential greengrocers or convenience shops, you know, nobody realised, you know, really how important they are to being able to fill up on your toilet roll stock before. So,
it's a basic, really,
essential goods, exactly. So, you know, forget the usual basket of greens. You know, toilet rolls is going to be featured in the RPI index from now on. But it's also about where some of these services are unique to a particular area. So you've got things like village shops, and if you've got a shop which is it hasn't got a shop nearby within, say, 1,000 meters, and I think it's 280 square meters. So it's sort of like a village shop. It's an essential local service, and it's now a community use. And so it's going to be restricted. You can't necessarily go from one to the other. Right. And shops and offices will go into the same use. And so there's freedom of movement amongst all of these. But it affects different applications in different ways. And these changes are sort of on a trial period. They take off from the 1st of September, so they will affect all new full applications for planning permission, outline applications for planning permission, and listed building consent applications from the 1st of September all the way through to the 31st of July next year. After that, we don't know. They may still keep the same use classes order, they may change it slightly. And with those doing prior approvals, so like office to resi, retail to resi, the legislation makes clear that forget these changes in terms of where a shop is and what a shop is and what its use class order is. There's no change as far as those prior approvals. So if you were doing a prior approval now and you're going, well, I'm just about to submit my application either before 1st of September or after 1st of September for office to resi. How am I affected by this? Do I lose my PD rights? No, it carries on as normal, at least until the 31st of July next year. The government said it's going to be reviewing the General Permitted Development Order and these use class changes in the meantime. So there's going to be further stuff coming forward.
I see. Okay, so watch the space on that one.
Yeah.
Yeah.
Those changes, although they say they're temporary, by the way, up to 31st of July for the use classes order, it doesn't say the same for the changes to extra stories to buildings and knocking down and putting up new buildings. Those are permanent as far as we know, but I think the government may have to tinker with some of the conditions around those, because there are other factors and complications which developers will have to take into account. And some of those factors, such as building regulations or car parking restrictions, so on and so forth, they might frustrate what the government is trying to achieve here. So they might have to go back into the legislation and change it again.
I see. So very important to work with very good experts, seek advice, and be very, very, very clear on what you're doing, and be aware things can move, a lot of moving parts.
Well, I think that's a really good comment, actually, Michelle, because when you look at it, I think, particularly for those who are starting off with development, it's all about trying to manage your risk and trying to manage your costs. And this is why permitted development and prior approval is so useful to people who are beginning their property journey. They're beginning to get on the ladder, and they don't want to be spending thousands or tens of thousands of pounds on reports. And, it can be very, very expensive for them. And so the people have been used to almost like a tick box exercise with a lot of these PD rights, thinking it's, a quick way to get some quick wins and get some value out of there. But the list of conditions is longer than we've seen with office to resi, for instance, and retail to resi. There's more things that's thrown in. There's perhaps going to have to be more reports done as well. And it's going to be difficult for costs to be kept at the same level on a lot of applications before. There's a lot more planning judgment as well. So I think there's two main things out of that. You need to seek expert advice very early on. And when you're going forward with these applications, bear in mind that they are related to a large degree on matters of opinion, planning opinion, stuff like that. So it can be very difficult to predict exactly what the outcome is going to be. And you may need to spend a bit more money on some of these reports than you thought you'd need to in the first place.
Yes, absolutely. A lot of care needs to be taken, because budget would be blown quite early on. So
absolutely,
you've got to have a good team around you. I totally agree. So another little question I've seen pop up in some of your very useful LinkedIn and social media videos since these announcements last week was how Article 4 comes in as well. Do you want to mention anything about that?
Yeah. So, Article 4 directions can take away permitted development rights. So how we as planners think about this is we ask ourselves the question, first of all, is what we are doing development? So does it involve building operations, building work, or anything that changes the external appearance of a building? Or does it involve a material change in the use of the character? So if it doesn't involve any of those, it's not development, and you don't have to worry about Article 4 directions, permitted development right, it just doesn't come into play.
Interesting.
If, however, let's say you now, from the 1st of September onwards, you want to change a use from a retail shop to a business use class, and that might be important for a lot of developers because they're buying multi-use buildings. Some of the shops, because of structural changes in town centres, some of the shops are failing, but there might still be a market for renting it out as office space. And you will know yourself, you'll appreciate yourself that when you're working with investors and banks, a lot of your part of the profit stack is often tied up in either the last few units or the commercial value of the retail unit. And it's a tough decision, which you may have to let go of certain opportunities if it just doesn't stack on a commercial valuation for you. So being able to go to a more viable commercial use may preserve just the right amount of your profit share in the stack to then give you the incentive to go forward and kickstart development, which is at the margins. So it's a very, very interesting, very, very important change. But there are a number of other implications around this. So for instance, if you are, we've got a site at the moment, a client site, which is, it's currently a community hall. So that sits in Class D1 use. To go to residential, we need to show that there's no need for the community use at all. So the council will have a policy that says no change in community use is allowed. However, we can go from a community use to a medical facility or a creche without the need for planning permission at the moment, because it's both in D1 use. So we're going to change it into a medical facility, a dental practice or a creche or a day nursery before the 1st of September, get an occupier in. We can do that without needing planning permission. Overnight, from the 1st of September, that then becomes a Class E use, and it sits in the same use as a retail shop. So we could then change it to a Tesco Express. So it increases the commercial value of the site, which also helps from the point of dealing with moving out to an affordable, to residential use afterwards. Now that change
Amazing. Yep.
to a shop, we can make that change after the 1st of September if we're already in a creche or a medical facility, because after the 1st of September, we then sit by definition in the same use class as a shop. But that doesn't require planning permission. Because it's under the use classes order, the government or the council can't touch it with an Article 4 direction. So use classes order is really powerful as far as that's concerned. And you can improve the value of sites and development overnight in doing that. And a lot of these changes, the local authorities will not be able to touch by use under the use class order, because not by Article 4 direction in any event, because Article 4 directions do not relate to use classes order. So it only relates on the next stage. So we're at the level where, is there the need for planning permission anyway? Mm-hmm. Is there a material change to the external appearance? Is there a material change in the use? But if there's not, because it's, say for instance, you're in the same use classes order, then regardless of an Article 4 direction, you can make that change. It's only then when you want to change within permitted development rights or prior approval, then you have to look at Article 4 directions. Now, with the 7 PD rights that came in last week, and that were new, so extra stories to existing blocks and knocking down a building and putting a new building up, they are permitted development rights. So normally you would need planning permission for them, but the law says we're going to make it easier for you to obtain planning permission this way. But that makes it a permitted development right. Those councils can bring in Article 4 directions against. And we'll have to look out for that. I think when you're looking to take forward an opportunity in that, now always look for the Article 4 directions of the council's site. And if they make them and they post them up on the council's site, they usually don't come in for many, many months after. They're what's called non-immediate, because people have human right, that they have a human right or a vested European Convention right in relation to how they can use their own property. And because of the human rights law, governments and local authorities can't withdraw Article 4 directions immediately in most cases. So there's usually like a 12-month delay. So there will almost always be a window when you can put in your PD applications and try and get them through. Even if, let's say 1st of September, your local authority starts slapping down an Article 4 direction and makes one there, it might not be able to come into effect for another 12 months, for instance. So you'll have a period of grace.
Right.
You can get your planning permission. You're going to not just get your planning permission in, but get your planning permission granted or your PD granted within that time.
Okay. Very.
All a bit complicated. I hope I explained that.
No,
Fair enough.
you did, but I mean, it's very clear that you do need to consult experts, and you need someone who's very up to speed and has obviously, dissected everything as you have, and you've got to make it very clear that things are not completely black and white, are they? Things
No.
are subject to change. So there's a very, it's an awful lot to consider. So, I mean, obviously Article 4 has spread, across the country quite a lot in the last 5 or 6 years.
Yeah.
And who knows what the government may do with Article 4. I mean, do you see that as something they may play with, or
I don't think they're going to change the Article 4 laws. I think a lot of it rests upon each individual council as to what their local priorities are. I think they'll take one look at a lot of the new law on the permitted development right. They'll see a long list of stuff that they would normally be concerned about. I think the only thing they can't control, principally, the main things are dwelling mix,
yes,
dwelling sizes. So they might still be concerned about rabbit hutches, but then again, you need to prove that there's enough adequate natural light coming into rooms now, and you have to provide full floor plans and elevations.
Mm-hmm.
So there's going to be less concern around that, and affordable housing as well. So some councils have affordable housing thresholds at 1 unit, 5 units, some at 10 or even more units as well. So they might lose affordable housing in respect to some of that as well. But they've still got quite a lot of control reserved, and they might just play a waiting game to see what the impact is, because I think some of the other collateral things around bringing forward development on these sites, like building regulations and car parking, is not going to be straightforward. So I'm not sure they're going to be seeing swathes of pressure on their urban areas as a result of this that might then get them alarmed and think, oh, we need to do something to stem the control of this and bring an Article 4 direction. So I'm not sure councils will be quite that quick to act. I think the one that they might act on in most cases is the one for demolition of buildings, office buildings and purpose-built blocks of flats that were in those uses as of the 1st of January 1990. They have to have been in those uses since then. They might act against those, particularly if they're office buildings, because currently a lot of local authorities, they don't want to lose employment floor space. They've already lost a lot of them to the PD rights. And they have then policies. They've already kind of excluded some of these through PD rights, leaving developers to have to prove through a marketing exercise over like 12 months or 18 months that there's no demand for the office space. This now cuts through all of that and says, no, actually, you don't have to do that, Michelle. You don't have to market it for 12 months to prove that to us. You only have to show it's been vacant for 6 months before the date of your application. And then, as long as you do that, then in principle, you can do it. You just have to tick all these other boxes and submit all these other reports. So I think that's one where we might see quite a bit of movement from councils on Article 4.
Okay, well, we'll watch this space. So exciting times out there, a lot of opportunity, but a lot of care needed to be taken.
Absolutely.
Yes. So just to sort of summarize, obviously there's a lot of, challenges amongst all these new PD announcements and things. Is there anything we've missed that you'd like to sort of add in?
I don't think so. I think we've pretty much covered everything. In terms of the practical points, I think the main things are that certainly when you're looking at these opportunities, you've got to kind of match the right PD right to the right building. So the first 6 I talked about in terms of the extensions on existing buildings, they apply to different buildings depending upon whether or not it's terraced or detached, it's in mixed use, or it's a single dwelling house, or it's purpose-built blocks of flats. So it's a sort of a mix and match. You don't, or rather not a mix and match, you only apply one particular PD to one particular type of building. You don't mix and match them. They're very specific. They've been defined in little silos, depending upon what your building type is and what the mix of uses is as well. So once you've found that, then you have to go through the conditions and restrictions. You need to seek advice early, and you need to be prepared to cost up the reports and then think about how that then compares against your expected values on the site as well. So
yes, a lot to think about. And your videos and content over the last few weeks, and especially obviously the last week, have been invaluable. And I know a lot of people have been following those. And there's an awful lot to get your head around. And I believe there may be some further guidance from yourself coming.
Yes, yeah. Well, I mean, the law is evolving on all this all the time, but what's quite clear is that there is going to be a need for kind of really getting to know the planning system and to understand that as well, and particularly for developers who are concerned about having to pay large amounts of money for experts, and to do these sorts of schemes, you either have to have quite a bit of money and investor cash behind yourself, or you have to be quite experienced. And those starting off, it's daunting. It's very daunting. So I'm kicking off with a masterclass, which I'm hosting through the Property Investors News and with Richard Bowser. We're going to select a date in August and then publish it. It's just going to be over a couple of days, but it's going to be a nice, easy way for people. It's not too costly for people to start to get to understand how this works and the strategy, and to be able to give themselves a route map so they have kind of some clarity and certainty to find their way through the complexities of the planning system.
That I think will be very, very, very greatly received, and I'd say very popular. So I think that'll be brilliant. So, well, thank you so much. Goodness knows what we seem to time it very well when we have these conversations that we get off our Zooms, and there's been more announcements. So who knows? Are you expecting anything else this side of the 1st of September?
Not this afternoon, no, because it could have sort of happened on the afternoon of our last talk.
Well, who knows? But I mean, I do think it's been a big old couple of months. Somebody said it's the most change there's been since World War II. I mean, is that a way of looking at it?
Well, it might not be understating it in respect to some of the changes,
sure.
But we'll have to wait and see, because there are so many moving parts to developments, as you know.
Absolutely. Yeah. But it's exciting times for everyone in the industry. There's a lot of opportunity, but a lot of advice needed. So, well, thank you very much. And obviously, a lot of people see you on LinkedIn. You're quite active on there. So we'll see you on LinkedIn, Facebook, and talk to you again soon. So all the best.
Thanks, Michelle.
Thank you.